Much. Over to you, Orla.
Thank you, Angela, and good morning. The sun is shining on a lovely spring morning in Cork, and I hope it's shining wherever you're joining us from. It's my pleasure this morning to welcome our colleagues from the State's Claims Agency, Dr. Cathal O'Keefe. Cathal is the head of clinical risk in the State's Claims Agency, where he leads the clinical risk unit. That unit works in partnership with us all to advance safety in health and social care delivery. Prior to taking up this role, Dr. O'Keefe worked as a consultant gastroenterologist, but he also has extensive experience in the not-for-profit sector, and he worked with a number of different overseas development agencies on health and education programs in sub-Saharan Africa. So you're very welcome, and thank you for joining us, Cathal. Cathal is joined by Ms. Mary Godfrey, and Mary is a senior clinical risk manager in the clinical risk unit in the State's Claims Agency. Mary has a very wide-ranging experience extending across nurse education, the development of national policy, professional standards and guidance, and implementation of national service initiatives, as well as quality and risk management, research ethics and governance. And as if all that wasn't enough, Mary was a member of the Nursing Midwifery Board of Ireland between 2007 and 2012. And finally, we are joined by Mr. Gary McCann, and Gary is a senior clinical claims manager, and he joined the State's Claims Agency in 2015. Gary qualified as a solicitor in 2001, having trained with McCann Fitzgerald solicitors. He specialised in the area of medical negligence and has significant experience in all aspects of medical negligence claims. Over the course of his career as a solicitor, he advised clinical practitioners and their indemnifiers on defence of healthcare related litigation. Gary is also an accredited mediator. So thank you all for joining us, and I will now hand back to my colleagues in the State's Claims Agency to conduct the webinar.
Thank you very much, Orla. Thanks for your welcome. And just to say on behalf of Mary and Gary and myself and colleagues at the State Claims Agency, we're very happy to be here today, and very grateful to you for the invitation to talk to you today. And I was saying to Angela before the meeting started that we have a long history of collaboration with the HSE in relation to open disclosure, which I'll take you through some of the milestones in a couple of minutes, but it's always been a very positive relationship, as Angela and I were agreeing earlier. And it's taken many different forms at different times. And we're very supportive of the work that's undertaken by Angela and her team in the National Office for Open Disclosure, the HSE's National Office for Open Disclosure. Next slide there, Mary. So Angela asked us to take you through today, I suppose, to outline really what it is we do in the State Claims Agency, an overview, I suppose, both of our clinical risk function, but also our claims function. So the way we're going to do the webinar this morning, I'm going to start off giving a bit of sort of a high level view of the work and the mandate of the State Claims Agency. Mary's then going to talk to you a little bit about the work of the clinical risk unit. Gary is going to talk to you then about the work of the clinical claims unit, and also take you through some of the issues in relation to, you know, inquests and those sorts of things that I'm sure people joining the webinar today, you know, it may happen at some stage that you may be involved in something like that, and Gary's going to give you some background to that and some context and some practical advice as well. We're going to talk a little bit then about, you know, how we see, or how sometimes open disclosure arises when we look at claims, and some of our advice and I suppose our thoughts, and from our perspective in State Claims Agencies, our view and perspective in relation to open disclosure. Next slide there, Mary. So I think everybody on the webinar today is probably well familiar with the definition of open disclosure. This is the HSE's definition from 2019. I suppose there's probably a few things that open disclosure is inextricably linked, I think, with a few things. Firstly, with communication, and I think we very much see open disclosure as being part of the broader process of communication with patients. I think the second thing that it's linked in very clearly with is incident management. And I know within the incident management framework that open disclosure is explicitly called out as being a key part of incident management, and it can't really be separated from that. And the third thing I think that open disclosure is inextricably linked with is learning. And that's the other thing that's sort of called out here. And because if we really want to learn from adverse events and or things that go wrong, patients need to be very much involved in that process. And open disclosure is clearly the process by which patients are made aware of and can become involved in the process of learning from adverse incidents as they occur. Next slide there. So just, I suppose, just to give you a brief history of the State Claims Agency's involvement in open disclosure. And this really goes right back to the aftermath or in the years following the publication of the Commission, the report of the Commission on Patient Safety and Quality Assurance, which was chaired by Deirdre Madden and which made recommendations in relation to open disclosure. And I guess at that stage, we recognized that this was an important issue that needed to be addressed. And we ourselves developed or appointed someone within the team. You may remember Anne Duffy, who was appointed in the team to look at the development of the SCA's response to open disclosure. And that very quickly led on to collaboration with the HSE and with Angela and with her team, initially on the research, development and implementation of the recommendations of the Commission. And that led on to the development of a national training programme, which was piloted in a number of sites, and then the subsequent rollout of a train-the-trainer program, which we were very heavily involved with. That involved both people from my team, although I wasn't there at the time, a lot of this predates me, but people from my team at the time, partnering with Angela and her team in terms of delivering training. And we were also co-authored with HSE the initial policy and guidelines around open disclosure. We all know what happened in 2018 and the cervical check litigation and the Scally report. So a number of important things have developed since then. Firstly is the establishment of the HSE National Office for Open Disclosure and a steering committee to oversee the work of that. And I was delighted to be invited to sit on that steering committee, and I continue to represent the State Claims Agency on that. The Independent Patient Safety Council was established a couple of years ago, and again, I was invited to sit on that. And one of the first pieces of work that the committee undertook, or the council undertook, was the development of recommendations on a national policy framework for open disclosure, which were published last year, or year before, I think, at this stage. And we're continuing to work closely with Angela. And one thing we might come back to a little bit later is, trying to measure open disclosure, how we go about that. And one way to do that is to look at evidence of open disclosure being recorded on NIMS. And we're glad to be working with Angela's team on a piece of work to look at that specifically. So, as I say, a long history of involvement with HSE in relation to open disclosure, and very happy to continue that involvement. Next slide there, Mary. So I'm just going to give you now, I suppose, take a bit of a sidestep and talk to you a little bit about our own mandate and what it is we do in State Claims Agency. Next slide there, Mary. So I suppose just to point out that, that there was the NTMA and subsequently State Claims Agency were founded. There was legislation which established the foundation of the NTMA and the State Claims Agency, where the NTMA acting in terms of claims management or risk management is acting as the State Claims Agency. So important to note, I think, that not just our claims management function, but also our risk management function is written into legislation, and we are mandated and required to provide a risk management service and function in relation to the occurrence of incidents and claims. Next slide there, Mary. And I think and we're sort of represented today Myself and Mary represent the risk management side of State Claims Agency, the clinical risk management side of State Claims Agency, and Gary is here representing the claims management side. And those, I suppose, are the two main functions: the claims resolution function, which really involves when a claim arises, managing that claim through to conclusion, and then the risk management function, as I've said, written in our legislation, that we have a duty to advise and assist the state authorities in relation to the management of litigation risks. And I suppose that's very much with the lens of looking at incidents which may result in claims and claims as they occur. So that's really our focus. That's the starting point for our work, is looking at incident data, looking at claims data, and on the basis of that, providing advice and assistance to state authorities. We have two other, I suppose one other unit to mention is the legal costs management unit. So that is a unit set up within the State Claims Agency with the explicit function of trying to manage legal costs associated with claims management to the lowest possible level. And we also then host or co-host the National Incident Management System. Mary, next slide there. And I suppose just to talk about the National Incident Management System briefly, this it sort of more or less does what it says on the tin. It's a national incident management system. And I suppose the thing about it is that it is a national system. It's a system to which adverse incidents occurring in the provision of healthcare are to be reported. And when DSAs, delegated state authorities, report incidents onto the National Incident Management System, they are fulfilling their duty to report incidents to ourselves in the State Claims Agency. But obviously the National Incident Management System is very much a partnership between ourselves and the HSE, and we work very closely with the Ordis team and increasingly closely with Ordis team in terms of the ongoing governance and management and continuous improvement of the National Incident Management System. Okay, next slide there, please. So just from the State Claims Agency perspective, firstly, it's not just about healthcare. We indemnify, obviously, the services providing publicly funded healthcare in the country. So obviously that involves the HSE, it involves all the statutory hospitals, voluntary hospitals, and publicly funded health and social care services. But as well as that, we do provide, we manage claims and provide risk management advice in relation to non-clinical services as well. So, for instance, the Defence Forces and Garda Síochána and a number of other state bodies where we provide indemnity and also risk management advice to all of those. Next slide there, Mary, thanks. And I suppose the way we provide sort of state indemnity, as it were, is through the provision of two separate schemes: the clinical indemnity scheme and the general indemnity scheme. So the clinical indemnity scheme provides indemnity to state authorities in respect to the provision of professional medical services, which is sort of essentially, the provision of clinical care. So the provision of clinical care and any risk and indemnity risk and litigation arising is all managed under the clinical indemnity scheme. The other then is the general indemnity scheme, which my GIS colleagues would probably give out if I described it as this, but it's sort of everything else that doesn't fall under clinical care. So it's in relation to, for instance, litigation that might arise. Well, firstly, in relation to non-clinical care, I mentioned things like the guards, the prison services, the armed forces, etc. So it covers claims in relation to those bodies, but also the non-clinical aspects of litigation which might arise in relation to healthcare. So that's, for example, in relation to staff members or members of the public, and that sort of that category of things. Next slide there, please. So just a little bit more on the clinical indemnity scheme, which I think is probably most relevant to the people on the webinar today. So what does it cover? It really covers professional medical services, which I'll describe in a little bit more detail in a minute. Also clinical care during transfer of patients, representation at coroner's inquests, and Gary will talk a little bit more about that. And also Good Samaritan Acts within the island of Ireland, not just within within the sort of the Republic of Ireland, the 26 counties within the full 32 counties. I suppose it's important to realise, and particularly for trainees and people coming through training, to recognise what's not covered. Obviously, private hospitals are not covered, although, just to say, in the context of COVID, arrangements were put in place whereby indemnity was covered extended to private hospitals in relation to the treatment of public patients as a consequence of COVID, to bring that extra capacity on board. But routinely, private hospitals aren't covered unless in special circumstances such as that. Private practice in private settings. Disciplinary hearings, and I think that's an important one to realise that. So in other words, if a complaint is made against you by a patient to your regulator, for example, to the Medical Council, we don't provide cover for that, nor do we provide cover for criminal cases. And we don't provide cover either for GPs who are essentially, I suppose, working as independent contractors. But the only exception to that is we do provide cover to GP trainees who are placed in GP practices as part of a recognised and accredited training programme operated through the ICGP. And I suppose the other thing just to mention is the enterprise liability. So if you go back before the clinical indemnity scheme was founded and a claim was taken against a doctor in a hospital, it would have been taken against the doctor and against the nurse and against the HSC, against the hospital in question, and possibly against 4 or 5 different named individuals. That's not the way it works now with the clinical indemnity scheme. The enterprise is now the entity, the legal entity against which the claim is taken. So a claim will be taken against the HSE, and that might involve a particular hospital and doctors, but the whole enterprise is included within that. So it gets away from that situation of having multiple claims and multiple against multiple individuals and representation by multiple different people. So it's a much more streamlined system. Next slide, please. And just to clarify what professional medical services are, essentially it's everything to do with the provision of clinical care. So the scheme covers registered medical practitioners or doctors and also dentists engaging in the delivery of care. It's all spelled out there, but essentially engaging in the delivery of care. And as well as that, allied health professionals who are called out there as well, pharmacists, nurses, midwives, etc. And anybody really who's working under their direction. So that would cover, for example, healthcare assistants and anybody who's involved in a hospital in the delivery of care or in a health and social care location in the delivery of care to a patient or a service user. Next slide there. And I suppose, as I said, there's 2 different schemes: the general indemnity scheme and the clinical indemnity scheme. It's not always entirely clear. Sometimes it's very clear. We've given a couple of examples there of the sorts of things that would fall under the clinical indemnity scheme: a patient prescribed an incorrect medication or sustaining an allergic reaction to a medication when the allergy was known, or suffering an unexpected injury during surgery. Those are the sorts of things that come under the clinical indemnity scheme. On the opposite side of the general indemnity scheme, sort of related to state of premises. So, for example, if a patient slips on a wet floor, and actually the issue there wasn't in relation to clinical care, that will fall under the general indemnity scheme. There is often a little bit of overlap between the two, and whether any claim arising is managed by the CIS or GIS is really determined by the teams within the SCA. Next slide there. And I suppose just to summarise then, those who are covered: non-consultant hospital doctors, nurses, clinical staff, public health doctors, nurses, community-based staff, other health and social care providers, dentists, etc. So really the full scope of people who will be working in relation to publicly funded healthcare. Next slide, please. And I suppose the thing about state indemnity is that it is a little bit of a two-way street. So obviously the state provides indemnity to locations such as hospitals and health and social care locations. In return for that, it is a contract, as I say, a two-way contract you are expected to report any adverse incidents or claims to the State Claims Agency as soon as you become aware of them. And recording incidents on NIMS is fulfilling your statutory obligation to do so. And then obviously, as needed, to provide us with any information or documentation in relation to reviews or anything like that that may be undertaken to assist us both with our risk management function and our claims management function. And I suppose there's two bits to that. There's helping us fulfill our statutory function, but obviously the National Incident Management System is then a huge resource of national level information, which is really the source of tremendous learning. And Mary's going to outline to you in a few minutes how we go about trying to mine that information and learn from it, and then feed that information back out into the system. So there's sort of the statutory obligation to report, but the reporting also provides us with a huge amount of information that we, and also Orla's team in HSE, and increasingly in a collaborative sort of way, are trying to mine, to try and extract learning, try and feed that learning back out into the system to try and inform risk mitigation. Next slide there. And finally, just for me, just to say that, just to remind you that having indemnity cover or insurance cover is a requirement from your professional regulator. So certainly, speaking as a doctor, I know that when I go on to register myself with the Medical Council each year, I have to tick a box to say that I have the appropriate indemnity and or insurance arrangements in place in order to practice. So it is that requirement to stand there, and as well as that, the requirement to engage in open disclosure is called out by the regulators as well. So I think now I'm going to hand over to Mary, if I'm right. Who's going to take you through the work of the Clinical Risk Unit in the State Claims Agency.
Thank you, Cathal. The Clinical Risk Unit, we have a strategy, and for the past 3 years, and our vision very much was that there would be a transformed clinical risk landscape, and that this would lead to enhanced patient safety and the reduced risk of litigation from patient or service user incidents. And to realise this vision, then we have 4 strategic objectives which are building on the mandate that Cathal has already referred to. And the first element would be in relation to data analysis and research, and this emanates from the incidents reported, where we analyse incidents, and we also analyse claims that are closed, to extrapolate the learning and to provide back into the system, as Cathal has mentioned. Our second key area of work, again coming from the legislative basis, is the area of risk management, and we are always providing clinical risk advice to the enterprises, hospitals, social care services that we engage with. And we also engage with the enterprises on emerging risks, and that is whether it's locally, regionally, nationally, as well. We also involved in much education and learning activities, again as a mechanism to inform about the learning from the incidents and claims that we see from the National Incident Management Systems. We also engage through publications and teaching, and I'll come back to those later, and also any conferences and webinars, which we would have had a series of them last year. We also are involved in influencing national policy, any policy development and implementation, again to all with a view to enhancing patient safety and reducing the risk of litigation from incidents. And we also sponsor programs and support programs that are in relation to patient safety. Incident reporting, as you can see from this slide, demonstrates the increase yearly on the National Incident Management System of all incidents reported. And certainly by the end of 2020, there were over 2 million incidents reported on the system. And there was a slight dip in 2020 there, you'll see, but again, if we think of what emerged in 2020 with the pandemic, and also a lot of elective work was reduced as well, so perhaps that has contributed to it. But you can see generally it's in an upward direction. And obviously increase in incident reporting is very positive for us, because high incident of reporting leads to demonstrates better culture of patient safety within organizations. One of the methods that we use in relation to looking at all service user incidents would be statistical process charts. And this is a mechanism for us that we can look at larger number of incidents to see are there any trends and patterns, also to look at particularly for special cause variation. And we particularly look at the type of incidents of which are quite large numbers are reported. For example, falls, pressure ulcers, serious self-injurious behaviour, violence, harassment and aggression, medications, and also say in relation to maternity services, postpartum hemorrhage. So, and if there's anything raised in relation specifically, we can drill down further to identify, is there any instance of specific concern that we need to further explore. And if you look at this chart, you'll see this extends from the 1st of December 2019 right through 2020 and into just the 1st of this month. And you can see there the special cause variation there in May of last year, where, as you will all recall, the cyber attack that occurred on the 14th of May, and of course that's just immediately afterwards, the National Incident Management System was closed down, was offline. And then, so that gives rise to that section in May, June last year. And then you can see the increase then, where the State Claims Agency commenced to support the HSE to report incidents, and some of you will recall sending in hard copies of National Incident Report forms, so they will be uploaded on NIMS, and that gives rise, you'll see the green pattern then. And then once NIMS was switched on, organisations or enterprises started reporting their incidents again. So that's how that is a mechanism we can use to assist us with reviewing incidents. We also conduct incident surveillance every quarter, and this is where we look at incidents reported in the previous quarter. And this just demonstrates you again from Q2, when we started the process in 2019, right through to the end of Q4 last year, which the analysis of the surveillance of those incidents reported has just been completed at the end of March this year. And when we're looking at incidents, we're particularly looking at incidents of specific interest or concern, or if there's a trend or pattern that would indicate from a certain location or just generally, and what learning we can extrapolate from this. So you can see there the overall number of incidents that would be surveyed, as it were, or that are part of this incident surveillance process, are in blue, and the incident of interest then are those that are in the grey beside it. So you can see there's quite a variation. The highest there would be in Q4 2020, and it's less for Q4 than say in 2021. It was down to 748 incidents. And depending on what is identified through our surveillance process, we do it as a team. We may identify, as I say, specific ones of concern. And for example, one that did emerge last year, or at the end of the previous years, was the whole area of choking and the risk of choking. And when we identify specific interests of that nature, of specific interest, or as I say, a trend, we then have issued a number of patient safety notifications. Managing the risk of choking arose, you can see, from specifically 43 incidents in a given time period. We give examples of it. And on the reverse of this patient safety notification, there is risk management, advice and risk management. And we were particularly delighted with this patient safety notification that it was done so as a collaborative and co-badged with the HSE, with INDI, and speech and language therapists as well. So because we're all here in the interest of patient safety and to get that learning out. And those patient safety notifications are then disseminated through the HSE and to the frontline staff, and they're purposely held at two pages to ensure that frontline staff can refer to them and do so, and that they are brief as opposed to a lengthy policy. There, as I say, there's been a suite of patient safety notifications issued over the past number of years, but two specifically in relation to open disclosure, which I'd like to bring to your attention, is first of all, the one here is enhancing communication. And this emerged very early on in the early weeks of COVID. And if you think back to yourselves, you may not be surprised around that, where there was 472 service user incidents reported NIMS in relation to communication. And you can see sort of three key areas there, where through the transfer of care, clinical handover, and interprofessional. We'll come back to those at a later stages. And there are key elements where communication can impact hugely on patient safety, and they're well recognised. The second patient safety notification, that's specifically relevant again to this session, is about recording and documentation in the healthcare record. And again, looking at a specific period, a specific quarter, 397 incidents were identified. And again, what the issues that were notified, and on the back then there's guidance about recording and documentation in healthcare records. And of course that also would include always documenting the open disclosure process within the healthcare record as well. Because obviously of the number of medication incidents, and this report was undertaken and it was published, and it looked specifically at the review of medication incidents reported by Irish acute hospitals, and this would also include the children's hospitals. And it looked at the type of incidents reported and focused in on key areas, for example, antithrombolytic agents. And it gives an insight, and whilst it's looking at the incidents in relation to specifically from the acute hospital sector, there is learning in it for all sectors where medications are administered to patients and service users. Needless to say, COVID-19, the pandemic, obviously we had a specific lens from the outset in end of March 2020 into April, say, where the communication patient safety notification emerged. And then obviously with the advent of vaccines at the very end of 2020, starting in 2021, we also started incident surveillance around COVID-19 incidents, but also then around vaccines specifically as well. And you can see here there was quite a number of service user incidents were reviewed, over 5,500 from that date in the 28th of December to July, so that we're talking about over a 7-month period. Almost a quarter of these were vaccine related incidents, and which accounted for over 1,322 vaccine incidents. And the surveillance in relation to these vaccine incidents was presented in this report in August 2021 to the HSE from our surveillance. We also looked then in details at the impact of cyber attack, which again you will know from your experience what it impacted, and this was a report also submitted in September last year. And key areas that were of incidents that were reported in relation to the impact in trying to deliver health and social care services were, for obvious reasons, no access to IT systems, no access to healthcare records. So obviously, if you've no access to healthcare records, there's a challenge in relation to access to patient history. Impact and provision of care and services, again, was widespread. Service user identification was very frequent, because if you can't access IT systems and you can't access healthcare records, obviously you can't determine service user identification as well. There were, needless to say, as health and social care professionals are always ingenious at doing, manual systems and workarounds were created to ensure patient safety and address those deficits that emerged. And there were also documentation issues that clearly arose, and diagnostic imaging, because again, if the IT systems were down, and the overall issue of cybersecurity was also in relation to incidents reported, was highlighted. Examples, just taking the first one of those on that previous slide, no access to IT systems. What type of examples and incidents were reported? If we take administration and communication, unable to send communication to other health and social care services, and non-completion of COVID pre-assessment questionnaires, which were so important in relation to patients being admitted for any procedures, and the incident reporting system was unavailable, and that feeds back to what you saw on the statistical process chart that I spoke to on the first slide in this section. Clinical care and patient information systems were hugely impacted, and again there were significant incidents reported in relation to these. Records, as mentioned already, couldn't be accessed. IPIMS, NIMS and Compass Scope couldn't be accessed. Unable to access and compare previous blood results and radiologic images and tests, which of course would impact then on the management and treatment of a patient who is being a recipient of care and treatment at a specific time. And then there was also no access to review service user infection control status, which is also very significant, particularly in the context of the pandemic. Equally, laboratory systems were affected because so dependent on IT. So there was processing of samples, again, which impact on care delivered. No electronic lab results, which I suppose we've got so accustomed to in recent years. No labels were available for samples, no access to blood tracking, and critical results could not be communicated from a laboratory up to, say, an intensive care unit or to a clinical area or to an ED department, which were so necessary. And there's just an example there of an incident we've extracted from NIMS, that a surgeon was unable to review x-rays as a result of the cyber attack. The patient and the instruments were already in theatre and discovered after screening that a different surgery was required. So we are so dependent on IT systems. And then that's taking an acute hospital setting from a surgical perspective. And then there was also incidents reported from the community where a patient, a mother following discharge following the birth of a baby, the discharge was faxed to a nursing office in the community. However, the fax machine wasn't operating due to the cyber attack. So the discharge summary wasn't received until much later. There was a delay in the postnatal visit, and that would have a knock-on effect then even in relation to, say, national blood spot screening, etc. So the catalogue of events can arise. Our other activities, just to give you a greater details in relation to our activities, I've already mentioned about clinical risk advices provided to individual practitioners and also to individual enterprises, and the clinical risk unit, the clinical risk advisors have certain areas of responsibility, so people tend to contact them, or in fact something may be sent in generically and we'll deal with it. As I mentioned already, engagement at enterprises, we're always willing to engage with enterprises and services, and we also provide indemnity advice when it's sought. And the most specific indemnity advice is that we worked in collaboration with our colleagues in the Enterprise Risk Unit to issue at the beginning of the pandemic, and you will recall, and also the cyber attack. We're very dependent, and we have also do an awful lot of work in relation to NIMS, and those of you in clinical practice will be aware of the changes were made to clinical procedures recently. And again, it's back to what Carl said about constantly identifying feedback from users, our customers, so that we can enhance the system and make it improved, that it meets the needs. Also, obviously, when COVID-19 occurred, we had to the system had to be revised and upgraded to facilitate reporting of COVID-19 from service users and indeed staff members as well. The next iteration was in relation to the vaccines, and now work will be in relation to the antiviral agents that are coming on stream. And the other area of development that members of the team are involved in is an electronic point of occurrence, and we're delighted that, say, for example, that's in CHI Connolly, and it's currently in pilot in Portiuncula, and we look forward to extending that. So it means then that the concept of having to use a paper incident form would be removed as well. So again, it's working towards increased digitalisation. National influence, as I mentioned, we're engaged in where wherever we can, obviously with the HSE, particularly with the National Women and Infants Health Programme, with open disclosures, Cathal has already mentioned, the Independent Safety Council, and in national consultations, and we're either invited to provide, to engage in consultations, or where they are brought to our attention. So we would have engaged in a number of consultations last year, for example, in relation to the Medical Council and the proposed new Code of Conduct, also in relation to nurses guidance, national guidance in relation to nurses referring for diagnostic imaging. And also in relation to, we also would have completed a consultation in relation to the Mental Health Commission last year in relation to restraint and seclusion orders that they were revising at the time. And we do that with the lens of what we have learned from incidents and claims to influence the development of policy. As education, I've already mentioned part of this, conferences and webinars. We have this, the visual there is from our own patient safety, National Quality Clinical Risk and Patient Safety conferences last year. We are involved in education and teaching in higher education institutes, particularly undergraduate and postgraduate programs across all professional groups, also the postgraduate training bodies, and many health and social care services who would come to us individually to deliver education sessions within their specific service, or where a number of services may come together as collective, and particularly in the virtual world now, to maximise the reach to as many people as possible through that area. And then this brings me on to our publications. This is our recent publication, the Clinical Risk Insights, the website, you can access it from there. And this is brought to you by our unit and the State Claims Agency to look at areas where clinical claims occur or are learning. So to assist you, to assist and feedback the learning from our work to you, to help you and assist you in your practice to deliver safer practice. And the first article there refers to how clinical claims occur and how to avoid them. My colleague Mark McCullough specifically looked at insulin, a very high risk medication, and the risks associated with it and how to minimise those. We've also looked at documentation and recording, and an update on NIMS as in relation to some of the developments I've already mentioned. And now I'll hand over to my colleague, Gary.
Thank you, Mary, and good morning, ladies and gentlemen. Gary McCann is my name. I'm one of the senior clinical claims managers who's involved in the management of these clinical claims concerning hospitals and enterprises around the country. So just to give you an idea of numbers, Colin mentioned earlier the general indemnity scheme and the clinical indemnity scheme. You can see on the slide there just the amount of cases that we're dealing with. Looking more particularly at the clinical claims, we've almost 3,500 claims with estimated liabilities of in excess of €3 billion. That figure of 3 billion is made up of estimated liabilities for compensation and the costs involved in these cases as well. So it's a bit of a dual factor there. I'll quickly move through this slide because I'll deal with these issues in more detail as the talk goes on. But just our role really, it's to investigate these claims, obtain the relevant expert reports, put in the reserves for these contingent liabilities, adapt a resolution approach. Do we try and settle? Do we try and defend these cases? We instruct our in-house solicitors or panel firm solicitors, depending on different enterprises, prepare for trial where necessary, liaising with the hospital and the clinicians during the course and lifespan of these cases, providing inquests or representation at the inquests, and then of course collaborating with our clinical risk colleagues with a view to trying to develop learning from the closed claims. So I'll spend a bit more time on this particular slide and we'll take it through the whole kind of life cycle of a claim. So the claim received by the State Claims Agency, typically the first inclination of any claim will be a request for the records, and that will be made usually directly to the hospital, for example. That's usually the first inclination. We don't know what cases will get off the ground or what cases won't get off the ground. A lot of cases, we understand, don't get off the ground from the plaintiff's point of view. After the plaintiff gets the records, they'll go off and get their own expert report, and then what we will usually receive is the pre-claim letter, or a Section 8 letter as it's also known. It's Section 8 of the Civil Liability and Courts Act 2004. And this letter should set out some information, basis of the claim, information of the wrong alleged. At that stage, when we get that letter, we'll nominate a panel firm of solicitors to accept service of proceedings on behalf of the authority. It'll normally be the HSE. Cathal mentioned earlier about different clinicians. In the old days, consultants would be named in these proceedings. We try and avoid that where we can. If we get a pre-letter of claim in, making reference to, for example, a particular consultant, we will go back saying there's no need to name that consultant in the proceedings. The correct identity is, for example, the HSE. The correct defendant is the HSE, in an effort to try and avoid people being named in these proceedings. So that's where we kick in then. We nominate solicitors to accept service of the proceedings, and the proceedings then arrive in the form of what's called a personal injury summons. It's the High Court document. These clinical negligence cases, they're majority, nearly always in the High Court, and that's just to do with the monetary levels of the courts. The Circuit Court is up to 60,000, the High Court is 60, up to the sky is the limit. Cases do settle below 60,000 in the High Court, but it's just a guide. Most of them, as I said, are commenced in the High Court. The personal injury summons will set out all of the information concerning the plaintiff's claim. This should include the allegations of negligence, the allegations of the breach of duty, and details of the injuries sustained as a result of that breach. So what the plaintiff is trying to do, the ingredients from the plaintiff's point of view, is to ascertain that there was a duty of care owed to the patient. So any patient going into a hospital is owed a duty of care, a duty to be treated appropriately in essence. So they must establish a breach of that duty, that the treatment was below an acceptable standard, and then they must prove injury resulting from that breach. So they're the kind of ingredients from the plaintiff's point of view. Moving on to the second figure there, claims investigated by the State Claims Agency. So we'll have the summons, we'll have the pre-claim letter, we'll also get a copy of the records, and we have our solicitors on board. We'll nominate relevant experts to investigate the claim. Depending on the type of case, we might need 1, 2, 3, 4, 5 experts. Whatever it takes, we will be instructing the relevant experts all the way through the case. And experts we might not think might be involved, as the case progresses, we might need to bring people in. For example, if a patient alleges a psych type injury as well as a physical injury, we'll need to bring in a consultant psychiatrist. We need to bring in experts to deal with the quantum aspect of the case, whether it's aids and appliances, physiotherapy, nursing care. So that's all brought in. We'll also be liaising with the relevant clinicians if and when necessary. And if you do find yourself involved in any of these cases and you're asked to make a statement or attend a consultation with either ourselves or the panel solicitors, what we want is the warts and all version of events at that stage, because we're better off to know at the outset if there's an issue or there was a problem with particular care or treatment. It's better for all concerned. It's better for yourselves as clinicians being involved in this litigation. It's better for the patients, and we can manage the litigation. If we know it's a case that needs to be resolved, and it should be resolved as soon as we can work towards that. It can take the heat out of the litigation from the plaintiff's point of view. It might also be the fact that a plaintiff will not go to the medical council or wherever the case might be to make a complaint. So it's better to know at the outset. If you're living with something, and it's dragging all the way through the case and you end up in the forecourts with us, and then at the last minute it comes to light that something went wrong at the start with the care, and we find ourselves at the last minute having to settle a case. You've been living with that for years. We've been working the case based on information you may or may not have provided. So it doesn't benefit. It doesn't benefit anybody. Oh, sorry. Moving on to the decision to settle or defend. With that, what will happen as the case progresses and we get all of our expert reports, we'll engage with counsel, barristers, whether it's senior counsel, junior counsel, perhaps both. A lot of cases we'll have a senior and junior counsel, and their advices, together with the advices from the panel firm and our own experience, we'll sit down together to say, okay, do we try and defend this case? Is it a case in which we're in difficulty, or are there some vulnerabilities there whereby we might have to settle a case but try and do so for what's a reduced value, taking on board the litigation risk? I'll come back to dealing with defending a case in a minute. So if we decide, for example, then moving on to figure 4, that it's a case which should be resolved, do we go by way of mediation or settlement talks? The settlement meeting is the kind of old-fashioned standard way of settling medical negligence cases and the general indemnity scheme cases. Usually it's a meeting of the 4 courts at 1 o'clock. Barristers meet at 1 o'clock in between court hearings. The meetings can be a bit hard and fast sometimes. People can be standing around corridors in the 4 courts in the law library trying to resolve cases. Mediation is a far more formal experience. Mediations will usually commence at 10 o'clock in the morning and might go on till 6, 7 o'clock in the evening. It's facilitated by way of a mediator, who's usually a senior counsel who's a lot of experience on medical negligence cases. Each party will have their own room. These mediations will usually take place in local hotels or in Dublin. We would use the Ormond building. It's a nice suite of offices. It's very comfortable for all concerned. And as I said, the plaintiff being the patient in these cases, the plaintiff and his or her legal team will be in one room. The defence team will be in another room. The mediator will act as a go-between between both parties, and it gives both sides time and opportunity to explore that middle ground. A patient might have a particular gripe about something. We might be saying it's a case which we're going to defend, but the patient might have a particular gripe about something that happened in the course of the treatment. And it gives an opportunity to go through that in detail. It gives an opportunity for the defence to say what our defence is in a case, why we say it's a case which we should be defended. And it gives the plaintiff real time to go through their issues and perhaps their expert report. So it's just more formal. It is quite beneficial. I've settled many cases by way of mediation which just would not have settled at an ordinary settlement meeting. So just moving on, 5, 6 and 7 really is to do with finalising the claim. If we know it's a case to be settled and we eventually settle it, we pay the compensation to the plaintiff. We'll deal with his or her solicitors insofar as the legal costs are concerned. Cathal mentioned earlier on that we have a legal cost unit. So we have legal cost accountants, in-house legal cost accountants, who we can get advice from and guidance from insofar as the costs of these cases are concerned. So just moving on to defending a claim, when we might defend a claim, all of the bullet points on the slide, what you're seeing now, will I suppose take into account both clinical and general claims. From the clinical point of view, we're looking at strong factual evidence and expert evidence backed up with good records. And they're the 3 big ingredients for us when we're coming to deciding whether or not we can settle these cases. I'm using a consultant, for example. If we have a consultant who's very strong about the treatment of care, that's backed up with experts, evidence, and it can be used, the records then can be used to support that. So the records are very important in relation to all of these cases. Just jumping down through the slide, another reason why a case might go on for hearing or might be pushed on for hearing is because the compensation sought is excessive. So what can happen in that instance is, if we feel a case is to be settled, we think we're in difficulty, and we try and settle it by way of a settlement meeting or a mediation, and we're just pulled apart. If the plaintiff, being the patient, is looking, for example, €200,000 to settle the case, and we think the case is worth €100,000, that can be a factor that will drive a case on for hearing. If that does happen, we can use a mechanism that's called a tender offer. So we can tender a figure of 100,000, saying that we think the case is worth 100,000 and that's reasonable compensation. If the case does proceed to trial, the judge is not told about this tender offer. It's secret to the judge. The judge will hear the case and determine the compensation to be awarded to the plaintiff. If the plaintiff doesn't beat our tender offer, we can then seek our costs from the date the tender offer was made. So to try and put that into perspective, if we try to settle a case on the 1st of July 2021 and we can't settle it, and we put a tender offer in of 100,000 on that date, and the case comes on for hearing on the 1st of January 2022, and the judge says, I think the case is worth €95,000. We can say, Judge, we made a tender offer in that. In the circumstances, we're seeking our costs from the date we made a tender offer. That's from the date of the 1st of July, 6 months earlier when we made the offer. So that's a big thing from the defence point of view. It puts the plaintiff, the patient, under pressure, because if they don't beat the tender offer, they could be obliged to pay our costs for a period of 6 months, which could take a big chunk out of their compensation. The other is a precedent case, a legal point that might need to be determined, and we can only resolve it by pushing it on for hearing. I'll briefly just touch on the statute of limitations, just to give you an idea of the time frame within which these cases should be brought. So for an adult over the age of 18, 2 years from the date of incident or date of knowledge. So it's 2 years from the date in which you know or ought to have known that you're injured. Okay, that's when the clock starts, that's when the 2 year runs. If you go in for a procedure on the 1st of January 2020, and a marker needle, we say, is left in situ on the 1st of January 2020, and no one realises it's missed on account or whatever. If 5 years later you've been having trouble with your back, niggly pain, or whatever the case might be, 5 years later that needle comes to light by way of another scan, your 2 year clock only starts 5 years later when the needle is identified, when you know that needle was left behind. Okay, so you're not statute barred saying, oh listen, that happened 5 years ago, it's too late. It's only when you knew or ought to have known. For minors under the age of 18, 2 years from the date of reaching their majority, if the parents, for example, haven't already brought the proceedings on their behalf. So a child who's 16, something happens, he in essence he or she have up until they reach the age of 20 to issue the proceedings. Where somebody has a disability and there's a lack of mental capacity, there's no time limit within which the proceedings must be brought. So usually we will see this in cerebral palsy type cases, where you might read in the paper that the birth occurred 10, 20, 30 years ago, and that's why there's no time limit. They haven't got the capacity, the time limits don't apply, and that's why you see these cases being taken later on. So that's just a brief run through on that. The possible outcomes, as I said, can be settlement of the action. We can lodge or tender in court to try and satisfy the plaintiff's claim. The plaintiff might discontinue the action. That happens as well. It can happen at any stage. The plaintiff, as their investigations progress, might realise actually we don't have a strong case here. We're not prepared to run it all the way. As these cases make their way towards a trial date, there is an exchange of expert reports between both sides, and that can be a reason for a plaintiff to discontinue action. It can be a reason for us to change our mind to go from settle a case or from defend a case to settle a case. There could be something in the plaintiff's expert report that our experts or treating clinician hadn't considered, and it can come to light then. And likewise, that can happen on the plaintiff's side. The alternative is a full court hearing, and everything is at hearing then in that instance. Just with regard to court hearings, I know the kind of general word around is everything settles, and you're correct. High 90% rate of settlements, I don't know if the figure is 97, 98% of cases will settle. And that's true. We don't know which cases are going to settle. We have to prepare them all as if they're going to go on to hearing. But I think one important point what I should make is that the plaintiff's legal team are ethically bound to be in possession of an expert report before they issue their court proceedings. So it's not a case of every disgruntled patient, for example, saying, I'm going to sue and running down to the High Court to have a summons issued. For that to happen, the solicitors and barristers involved on behalf of that plaintiff, ethically, they should have a supportive expert report. So they're kind of one step up the rung of the ladder before we know anything about these claims. They should have an expert report backing up their claim, so to speak. So what do you do if you find yourself embroiled in one of these? It's easy for me to say, don't be alarmed. I'm not the one receiving that letter or the call from your hospital coordinator. But if you do find yourself involved, notify your claims coordinator or contact us directly in the State Claims Agency, and we will get involved on your behalf. If you are asked to make a statement, as I said, we want the warts and all versions so that we can deal with it as best we can. Any statement that you, as a clinician being involved in any of these cases, if you're asked to make a statement, it'll be privileged. The patient is not going to get this statement. So again, don't be shy to put something in to say, perhaps I should have done this or perhaps I should have done that. It's fine, we're not there to judge, we're just there to manage the litigation as best we can. So that statement, it's not going to go and find its way to the plaintiff. You know, so don't be, I remember one example, I remember talking to an NCHD, he was actually in Australia, he'd been involved in working in an ED department and liaising with him in relation to a claim, and he had strapped a finger in a particular way, and it turned out it should have been strapped in a different way, and he was great and upfront about it, and he said, that's the way I was taught, and that's what the consultant had identified and showed me what to do. And that's what we knew then it was a case to be resolved, and we got rid of it as soon as we could, and everybody was happy. So it's yeah, the warts and all versions is the big thing that I should say. The inquests are held when there's an unexpected death, so it's sudden, unexplained, violent or unnatural. Inquests are completely different to claims. The coroner is obliged to investigate certain deaths. Claims can settle, can be discontinued, anything can happen at any stage. But once an inquest is directed, it will happen. So there's no settling an inquest, there's no having it discontinued. They will proceed. They're held in public, so they can attract publicity, and that's, unfortunately, it's outside of our control. Deaths in hospital, when we'll have inquests, and I won't dwell on that really, as again it falls back into the category probably of unexpected or unexplained or sudden. The purpose of the inquest, it's a fact-finding inquiry with or without a jury. Certain inquests must have a jury. Deaths from road traffic accidents must have a jury. Otherwise, it can be at the discretion of the coroner himself or herself if they want to have a jury present. It's to ascertain the who, when, where and how the person died with a view to determining the medical cause of death. The questions of civil or criminal liability should not be considered, and that's again easy to put that onto a slide, and people who've been involved in inquests might say otherwise. We will object to questions like that. The coroner shouldn't allow them. The coroner shouldn't allow questions to say, was it negligent to do that? That's not the function of the inquest, and your legal team should be there to back you on that as well. But it's like everything, we're dealing with coroners, we're all human. The coroner is facing a family sitting in a courtroom who are asking questions and who want answers, so there can be a bit of leeway, unfortunately, and that can be to the detriment sometimes of some of the witnesses. So it should be inquisitorial as opposed to being adversarial. We see more and more inquests attracting more publicity, and again, there's nothing we can do. Some lawyers will try and push it as far as they can, but again, we're in the hands of the coroner, so to speak. So the notice of the inquest, it's the coroner who decides on the witnesses to be called. It's not the lawyers involved from the enterprise. It's the coroner who will decide who he wants or she wants in giving evidence. The coroner can request the statements, depositions themselves, or they can ask the Gardaí to do it. They can use the guards to do that. Again, if you're asked to provide a statement, some people are happy to go it themselves, but you're entitled to legal representation, and why not use it? We're here to look after you. We're here to do our best for you. So we can't draft a statement for you, but we can give you a steer on what you should or should not include in the statement, and provide just practical information as to what will happen. So don't be shy to use this. Your role is to assist the coroner in determining the cause of death. If you are asked to make a statement, you must be familiar with the healthcare records. You have to go through them yourself and really know them inside out. Again, I'll just quickly run down to the slides, set out your name, qualifications, experience at the time. In chronological order, set out your treatment of this particular patient. Refer to records or the entries if relevant. If there's a discrepancy in the record, you can identify it or refer to it in your statement. And what you need is a true and accurate account of the facts, and after that, you just won't go wrong. Matters of hearsay, referring to other people. If the coroner wants to hear about somebody else, he'll ask that other person for a statement, and it might be 2 or 3 statements later when he realises he needs a statement from the ED consultant or someone in surgery, for example. Expression of sympathy may be offered to the family. At the bottom of it, you can say you want to offer your condolences and sympathy to the family, and that's fine. And you should sign, date, and keep a copy of it. The hearing itself, the evidence is under oath. Usually the guards will go first and identify the deceased. Then you'll have the factual witnesses, again, in their order of involvement. If you had the paramedics who picked somebody up in the ambulance, goes into ED, into intensive care, or whatever, that's the sequence of events in which the evidence will be heard. Your statement is usually read into court, into evidence. The coroner might have questions, the family's lawyers might have questions, and the pathologist then will usually give evidence as to the cause of death with a view to reaching the verdict. And there's the various different verdicts that are open to the coroner. Just the practical advice, and I'm just conscious of time. I suppose the first bullet point and the last 3 bullet points are the most important. Prepare as if you're going to the High Court, and act as if you're going to a funeral. Inquests can be very emotive. You have a family there who are still grieving a deceased, even though it might be a year, 2 years later. It's all right back up for everybody. There's no winners here. It's hard for the clinicians, the clinical staff, nurses coming in. It's you know, it's very nerve-wracking from your point of view, and we're well aware and very familiar with that. And we try and do our best to make it as comfortable as we can. Just touching on the last 3 points. If you don't understand a question, say it. No harm in that. You're not going to be getting into trouble for doing that. So make sure you understand what you're being asked. If you don't know the answer to the question, say you don't know. You will not get into trouble for that. You will get into trouble for guessing an answer, because what will happen if you try and guess an answer, if you're sitting there and you're asked a question, you say to yourself, I should know the answer to this, and at 99% sure the answer would be X. If you go down that route, you're most likely going to tie yourself up and get yourself into trouble. These inquests, and the same with court hearings, it can be 1, 2, 3, 4 years post the date of any particular treatment of your involvement. You're not expected to remember everything. So if you don't remember, that's fine. You don't want to find yourself in a situation where you answer one question, then you really get hit with a hard question, and then you say, I don't know, and then you might get a lawyer saying, well, you could answer that question 2 seconds ago, and now I'm asking you this question is quite similar, it was at the same time, and you don't know the answer to this. So that's the type of thing, and then you're thrown and you're caught, and you don't know what to do. So if you don't know, say you don't know, and there's no harm in that. And I think really that takes me to the end of what I had to say. I'm sorry it was a bit of a whirlwind tour. I was trying to cover as much as I can, but I hope it was of some benefit and interest to you. Thank you.
Thank you, Gary. And now that as Gary has gone through the process of a claim, I'm going to look at how in the clinical risk unit we look at learning from claims so that again that we can provide this information back into the health and social care system to enhance practice and enhance ultimately patient safety. So what learning opportunities have we identified through analysing claims? Well, the first thing is that it's very important that an adverse event, in fact, all incidents are reported on NIMS, not just adverse as in harm events, but also no harm incidents and near misses as well, that the red flags, so that they are there. Because incident reporting, again, as I may have said already, it's particularly a starting point in relation to risk identification and being able to learn lessons within an organisation itself before even claims rise. So it's important to report all incidents, as I say, on NIMS. Another area you'll see is also about have the practitioners involved got the knowledge and skills and competencies suitable to the task is something that has emerged as well as a learning opportunity. And there are challenges always with increasing technology in that the competency of individuals is maintained and further developed for appropriate assessment and monitoring. Again, we've identified through claims that often patients whose condition deteriorates are not monitored adequately, are not monitored maybe at all, or their deterioration isn't recognised. And that may be going back to the knowledge, skills and competency of the individual looking after them, or perhaps then it's not escalated. So very important that appropriate assessment monitoring is undertaken and is undertaken as required or as needed by virtue of the service user's condition or as recommended. Another area we've identified significant learning is the need to follow up on diagnostic tests and investigations, because whoever orders them needs to follow up. And if they're not followed up in a timely manner or followed up at all, again, the patient or service user will not receive the appropriate treatment in a timely fashion, and that can lead to further injury and a claim resolving from it. It's also important to pay attention to discharge planning. And if you can recall back to link this with the patient safety notification that I referred to earlier in relation to communication about the junctures of care, say transfer of care, and or from one unit to another, or from one organisation to another. So, and then in preparing patients for discharge, that it starts the day you commence, and that there's specific mechanisms are put in place, so that if a person is going home from, say, an acute hospital into community setting, that there's an appropriate discharge notice, that it's done so in a timely fashion, that if equipment is required, again, that it could be, that they say the community services can be enabled to have this in place for the discharge. If you look at the 4 icons underneath, and I'll come to these now, and learning opportunity, this specifically ties in also with, if you think of go back to the definition of open disclosure as open and consistent under communication. What we've identified that emerges as learning opportunities in claims is the need to communicate clearly with colleagues, be that using an ISBAR tool, ISBAR 3, so you're recommending risk. Also being able to communicate clearly with patients, and that the communication with patients is clearly documented as well, and that's clearly evident in the healthcare record, and which, as I said already, would include open disclosure. Comprehensive consent should be well documented, because again, from learning in relation to consent, it has emerged that sometimes there's suboptimal or incomplete consent, and it's not documented, and the process is not always clear in the healthcare record. There's so often in practice is the form signed, but from a claim point of view in learning, what is needed to be evidentiary throughout in the healthcare record is the process of consent, from informing the patient to ensure their understanding, answering questions, etc. That as it were, finally signing the form is the final one, if that's what it is concerned with. And back then to, again, what carrying on from what Gary was saying in relation to documentation as being key, to ensure that everything is documented very carefully, accurately, contemporaneously, bearing in mind that no notes mean no defence when it goes into a claim situation. So why do things go wrong? This is taking one of the areas from a generic learning perspective, and that would go, the learning would come from all specialties. Inadequate or substandard communication, either with service users or interprofessional communication in colleagues in the multidisciplinary teams or within service, is a recurring issue. It's common across all services and specialties. So it's not something that can be pointed at the finger at any one specialty, it's absolutely across all. And something that's very important to bear in mind as well. So if we look at communications issues, that what as it were have emerged, and what learning we can say through our analysis, I've made reference to substandard or omitted consent, inadequate follow-up arrangements for a review of the patient, failure to escalate to a senior decision maker perhaps, and you can see if this is compounded by failure to recognise a patient is deteriorating, and then if the patient is just recognised as deteriorating, then the patient's condition cannot be escalated to a senior decision maker, or in actual fact, where a practitioner would just not escalate to a senior decision maker in a position where the patient's condition as actually warrants it. Other areas where there's inadequate communications with patient service users, and that's why it's so important to document communication, the consent process, instructions about care, or risk benefits on alternative, because again, everything depends on the record, and if it's documented that it was, say that risks were identified or communicated with a patient, then that supports, as it were, the defence of a claim. But it's something we've identified in learning from claims that have been closed. Inadequate communication between members of multidisciplinary teams, and again, that is not just within a hospital or within a community setting. Substandard clinical documentation is very, very frequent, where it's not dated, it's not signed. The usual deficits can be identified, and these, in relation to patient safety notification that I made reference to, these what we would have identified from incidents would be set out in that as well. So it may be dated, not signed. So for example, if a claim has come in and Gary is going back to identify who is the carrier attributed to, it cannot be identified if it's not dated, signed and signed. And also then where communication where open disclosure is inadequate or omitted and not documented as well is another common issue identified. And again, all of these issues are common across all services and all clinical specialties. So when we looked at a number of claims in relation to specifically asking the question, is there evidence of open disclosure? And this builds on what I've just mentioned in relation to the need to document it. If we take different services, for example, the first one there, maternity and gynecology, we looked at, say, 57 claims. There was evidence of open disclosure in 12. Now, it maybe did occur, but if it's, again, going back to if it's not documented, we have to take it that it wasn't undertaken. And this is in total 7 claims. In perioperative, we, for example, as one example, say if there was a wrong side surgery, as an example of a claim. But where there's evidence of open disclosure, it is less in claims in relation to perioperative care. Medicine, say looking at 46 claims, there were 9. Community, it was greater actually in community open disclosure in the number of claims, and in children's there you can see out of a number of claims 15, it was 13%. So it's something to bear in mind. The evidence of open disclosure needs to be documented very clearly for us in trying to analyse that claims and provide feedback and learning to the system. So I'll hand you back to Cathal now. Thank you.
Thanks very much, Gary, and sorry, my video, there it is now. Thanks, Gary, and thanks, Mary. And yeah, really, I'm just going to wrap up quickly now. I'm conscious we're coming to the end, and we do want to have a bit of time for questions and answers if possible. But I think part of one of the recurring themes, or one of the recurring points about claims analysis, is that very often we see things that go wrong. The way we think of it is what goes wrong and why it goes wrong, and often we focus in on the what goes wrong, the error that was made, the mistake that was made, but that doesn't happen in isolation. It happens in a context, what we find when we look at claims is that communication is a very significant issue when it comes down to why things go wrong. And Mary's outlined, the full range of issues related to communication that can go wrong, which can result in an error and can result in an incident and a claim. And I think communication, so from our perspective, it's one of the most significant cross-cutting themes when we look at claims is communication deficits. And we would see open disclosure as being part and parcel, or one element of communication that can go wrong, that can result in incidents or claims. And we're not the only ones, I suppose, who think this. And this is a quote from Dr. Mark Dinwiddie, who is in MPS. And as he said, there's the things that go wrong, but also the predisposing factors, such as our communication skills, sensitivity to patient needs, and management of expectations, which may also result in claims occurring. Mary, next slide there, please. And if we look internationally, this is a study from the US by the Joint Commission in the US. Breakdown in communication was a leading root cause of sentinel events reported in JC in the United States in that period of time. 11% were due to communication issues in terms of adverse events leading to disability. 11% due to communication issues, which is actually almost double the number that were felt to be due to inadequate skill levels on behalf of the practitioner. Next slide there, Mary. And also going back to the same theme, it's about the relational aspect with patients as well, and that being so important. The decision to litigate was often associated with a perceived lack of caring and or collaboration in the delivery of healthcare, perceived unavailability, discounting patient and our family concerns, poor delivery of information, lack of understanding the patient and our family perspective. So again, back to communication and being open and transparent in our communication with patients which is essentially what open disclosure is. Next slide. And there is international evidence. I'm sure you've probably all seen this study that's from Michigan, which is often quoted, where policies of which demonstrated that when a policy of open disclosure was developed and implemented, there was significant improvement in litigation outcomes. We haven't equivalent data here in Ireland, but I think it's certainly something that we could look at. I know Angela's been in touch with us about this to see if we could look at this in some way to see what the impact might be here in Ireland. Next slide, please. So Mary's already mentioned these. Open disclosure should be undertaken or recorded in relation to service user incidents in accordance with the HSE's open disclosure policy. And as I mentioned earlier, it's also in line really with the incident management framework as well. And open disclosure should be recorded in names, and if not, a rationale, apologies for the typo there, a rationale for not doing so provided, and measuring how frequently and often open disclosure occurs, but also the patient's perspective of how they perceived it and how they received it and how it worked for them. That's a big issue to look at, and I know that Angela and her team are looking at that in the context of their work at the moment, both the measurement of, I suppose, the frequency of it occurring and also the quality of it. Okay, next slide. Yeah, and I think this is my favorite quote from in relation to communication, and I think it applies as much to open disclosure as to anything else. We think we've said it, we think we've communicated, but the patient doesn't necessarily recognize that, or that's not the way they receive it or they feel it. So I think that's all we have to say on our side. Sorry if we've run over a little bit, but hopefully we might still have some time for questions, Angela, if that's what you'd like to do.
Thank you so much, Cathal and Marion and Kieran there. So a lot of information, and fantastic information there, a lot of statistics will be very helpful to us there as well. And particularly interested in the area around documentation of open disclosure, because it is something that we do emphasise in our training. And indeed, even more recently, we've had, evidence where people have gone to look at open disclosure and they know what's happened, but they can't find the documentation around it. So again, just to emphasise that to all of our listeners today, that when you engage in open disclosure, make sure that you do document it very clearly in the patient's record, and for the formal open disclosure meeting that you send out a letter to the patient, confirming all the information was given at the open disclosure meeting. So I just wanted to, there are some questions actually in the chat box, but a couple of things around the incident surveillance report. So where can organisations source the quarterly reports they feel would be really helpful to them?
Sure, I can take that, Angela. It's that process that Mary referred to is our own internal process. So what we do is internally within the unit, we look at the incidents on a quarterly basis, and that generates a range of outputs. So those, we don't publish or issue reports in relation to the quarterly surveillance process that we do. But what we do push out then is so as a consequence or arising from that, what we may do is contact hospitals or health and social care locations directly about specific issues that we've identified, or we may generate things like the patient safety notifications, which are developed on the basis of the analysis that we've undertaken. I know a couple of people asked about access to the patient safety notification, so we do send out. Yeah, I thought I'd just say that we do send out widely through our own database. So we try and maintain our database in relation to individual locations, hospitals, etc. So they would go to sort of a number of named people in individual hospitals, go to the CEO, QPS leads, clinical directors, directors of nursing, director of midwifery, etc. So you should be receiving them in your location. If you're not, feel free to contact us at stateclaims.ie, and we can make sure that you're on the mailing list if needs be. We're probably going to put them on our website, but also just to say in relation to that we are working very closely. Orla's team is leading on the development of the shared learning hub. I'm not sure if the name of it has been finalized yet, but the shared learning hub, whereby learning from adverse incidents can be collated and appropriate recommendations issued and advice. I don't want to talk for it. It's not our project, but it's we're working very closely with Orla on that. And I think increasingly what we're probably going to see is any analysis, or it's feeding our analysis into that process. And then we'd have more of a conjoined, joined up way of thinking, a bit like the way we've tried to co-badge some of those notifications previously.
Thanks very much for that, Cathal. Just a question in the Q&A here. If you work in the public sector, are you leaving yourself open to being sued personally if you have private additional indemnity?
I might, I normally have a go at a question like that, but if there's a solicitor on the call, I think I should.
No is the short answer. So what can happen sometimes where we would see it if an NCHC or a doctor had additional top-up insurance with, say, the MPS for inquest or cover for an inquest, the consultant involved, the doctor involved, can come to us or can go to the MPS. There won't be, and we can work out between us who the doctor wants to look after, but he won't be leaving himself open for extra to be sued personally or anything like that. So no is the short answer.
Okay, thanks very much for that, Gary. And another question here, whether it's an incident within a Section 39 provider, is a requirement to input that data onto NIMS?
Mary, would you be happy to take that?
Sorry, Angela, could you repeat that? I couldn't hear you.
Whether it's an incident within a Section 39 outside provider, is there a requirement to input that data onto NIMS?
So it would be worked out within the service agreement. It should be specified within that, the annual as to the process.
Okay, so it's whatever was in what's in the service level agreement.
Yes.
Mary, what you're saying there.
Yeah,
that's fine. Thank you for that, Mary. There's just a comment here as well. I'd like to raise the point that we need to look at staffing levels and putting some of the money that will go out in claims into hiring staff in advance to reduce the risk of claims. They're just talking about whether there's long-term posts unfilled, and if there's any evidence that you bring back from the private sector, in relation to, would it be useful if we had evidence that would kind of lead to filling posts more quickly, perhaps in the public sector?
Yeah, I'm happy to. I think that's undoubtedly a huge issue. In terms of not just in terms of numbers, but in terms of appropriately trained staff, and like even if you just pick on maternity services, where we see some very high value claims. This has been called out by HICWA in terms of the challenge in terms of the numbers of consultants, the numbers of midwives, the appropriate training, etc. It's undoubtedly a huge risk issue. I think it's well known. I'm not sure from a claims perspective that there's much additional that we can add to that debate. Gary, I don't know if I'm to come in there.
There's very little we can add to it, Colin. It is a problem, and absolutely, if we had more staff in the system in the hospitals, I've no doubt it would lead to reduced claims.
Yeah, okay. In the context of an individual claim, I think Gary can correct me if I'm wrong here. We're very much dealing with a claim on its own merits, and it won't necessarily be mentioned that this issue arose as a consequence of a lack of a staff member or something like that. I think that's probably fair to say. But we clearly recognise that it's a huge impact in terms of patient safety.
Okay, thank you both. Another question there, who is defined as a senior decision maker, and is there a more senior decision maker? Or most senior decision maker, sorry.
I'm not, it probably, I don't know if there's an easy answer to that. It probably depends on who you are. I suppose that's the thing. So if I think, I'm a doctor, so if I think of it, I think it's really about a willingness to say, I'm not quite sure what to do here, and I need to ask somebody who knows more than I do. So if you're an intern, that might be your registrar. If it's your registrar, that's your consultant. Do you know what I mean? So I think it depends on who you are and what level you're at. And I think that will probably apply as well. Mary might be able to comment just in terms of, say, nursing and midwifery, for example.
I think it would be in relation, Angela, you could look in the context of, say, newly qualified staff nurses or midwives, that if they're unsure and that they would seek, they would escalate to a senior decision maker. And escalate can also mean discussion and learning from them too. And that can apply to any professional group if it's a more junior person. person. Or also, those with reference to the context, say, more independent practitioners like
But that is to have people contact him. I think there's that side to it as well. So certainly when I was growing up in medicine, and it's quite a while since I was an intern, but there was an atmosphere of fear around asking what you might think was a stupid question. And I think one of the best bosses I ever had was a consultant, and I said to him, I said, I hope you don't mind me asking a stupid question. And he said, there is no such thing as a stupid question. There's only a stupid answer. And I think that it's really that culture that you want, where people aren't afraid or feeling that they can't ask or that they shouldn't, or so it's trying to get away from that, get into a culture of openness and just being able to ask.
Okay.
And I think, Angela, it's ensuring there's a culture embodied everywhere of that psychological safety, that anybody, regardless of their level or membership of a team or whatever, feels safe to speak up. Because sometimes if there's something going wrong, it may be the most junior person that notices it. So it's creating that culture, as I said, to ensure that everybody feels safe to speak up at any time.
Absolutely, and it feeds into the principles of open disclosure itself, where it's kind of multidisciplinary responsibility and having that safe environment for people to be able to speak up and report and to engage in open disclosure as well as the needs arise. I think we're going to finish up there because we have run over time now. There are a few other questions, but we will respond to those questions to people in after the event today. So thank you for that. Just to say thank you again to Cathal and to Mary and to Gary. I think I called you the wrong name earlier, Gary, so my apologies for that. It's always a pressure when you're on these online events. So just an excellent presentation today, really helpful information. I know there's a lot of excitement in the group about the slides being available and having information available to them, and we will it is recorded today, and we will put this recording up on our website as well for people to watch it again if they want to, or to share with their services. I don't know, Orla, do you want to say anything there, but we might just finish up there.
Other than to thank everybody for their participation and their contributions to the conversation, and particular thanks to our colleagues in the State's Claims Agency for joining us. A very informative, educational, participative session. So thank you all very much.
And thank you for joining us today, Orla, as well. Thank you. So Kelly, if you bring up just the final slides there, if you can share them. That'd be great. Yeah. But just to point people towards our online e-learning program. So open disclosure training is mandatory for all staff working in the HSE and HSE funded services. So module 1 of the e-learning will suffice for most staff, and that's called Communicating Effectively Through Open Disclosure. For staff who have to engage in formal open disclosure meetings, so your managers, doctors, QPS staff, patient liaison staff, complaints officers, they should also complete, excuse me, module 2, which is open disclosure applying principles to practice, which really takes you through how to prepare for and engage in effective open disclosure and consultations. Sorry, my throat's a bit dry there. Just moving on there, Kelly. So our next webinar, we haven't got a date for it yet. We're hoping it's going to be related to GDPR and open disclosure, and that will be in May, but we will be sending out details of that to anybody who's on our circulation list, and we tweet out through Twitter as well. So that'll be coming up in May, so we'll send the date out to you as soon as we have it confirmed. Just to say, you will receive an email after the event today with a short survey in today's webinar, and we really would appreciate your participation in that survey. And as I said on numerous occasions to you before, we do listen to what you say, we do listen to what your recommendations are in relation to future topics, for example, and obviously our facilitators always like to get feedback on the webinar as well, so we will provide your feedback to Cathal and his team today. So thank you very much. In relation to the CPD, again, if you want your CPD certificate, just email the Open Disclosure Office, opendisclosure.office@hsc.ie. So again, just thank you from myself and from the Open Disclosure team for joining us today. We have a large number of people in the audience today, and thank you all. And said these sessions are for you, and hopefully you can bring some good learning away from it and change your practice in your service. So thank you very much, and goodbye.